want to talk to you today about self-defense under Canadian law, and specifically that our self-defense principles that are applicable under the Criminal Code are set out in Section 34 of the Criminal Code. There's a whole laundry list of factors which a judge is supposed to apply in that particular list. Now, I'm going to give you a couple simple examples so you understand. It's pretty clear cut. I mean, it's kind of common sense, actually, self-defense. You're acting reasonably to defend yourself in particular circumstances is the bottom line, and not using too much force and acting proportionally to the force which is happening upon you. So let me give you a couple pretty clear-cut examples. So you're standing at a bar, you're a male, I don't know, you're 180 pounds, and there's maybe a 210-pound bigger guy than you, a little taller, he's 6'1", you're 5'10". And this person's aggressive, they're drinking, they're kind of getting in your face verbally, you're getting a little nervous, you're shrinking away a bit. And for some unknown reason, out of the blue, they grab you and punch you. And they punch you in the jaw, and it's devastating, and they've got you now, and you're stunned. Well, clearly, you're allowed to use proportional force to defend you. You shouldn't pull out a knife, perhaps, in that circumstances, at least not yet, because that fight's not at that level at all. You should probably never pull out a knife, by the way. But there are situations where you can defend yourself with a knife, by the way. We won't get into those. We might get into those in another video, but not in this context. You've been attacked with a fist. It's appropriate to defend yourself with a fist, for example. So in grabbing and punching this person back a couple times and wrestling from the floor, and holding them there because you happen to be even a trained fighter. Let's say you're a trained fighter, but you still got to defend yourself, otherwise you're going to get hurt. Now the fight gets broken up. Clearly you've acted in self-defense. There's no question. This person was the aggressor. They're also male. Some of the factors they look at are gender, the role that they were playing. That person was the aggressor. The size differential of the parties. He was bigger. The proportionality of your response. You used a fist. You didn't use too much force. By the way, you don't have to weigh to a nicety your blow. Oh, I'm going to punch him this hard so that he just gets off me. No, you can punch. You don't have to weigh to a nicety. And if it caused a devastating injury, that's still going to be self-defense. Even if it resulted in death, and sometimes a punch can, it can still be self-defense. That'd be a terrible outcome, by the way. But clearly in the scenario I've given you, you've acted in self-defense in the fight. Thank God, no one got seriously hurt. The fight got broke up. Let's talk another scenario. Exact same factual situation. At the bar, person attacks you, punches you once or twice, say. You grab them, punch back, and now you have them on the ground, and they're totally under control. They're kind of dazed on the ground. You have an opportunity to get away quite easily. They're not even holding on to you now. And you vicariously give them even one more punch, let's say it's 3. Well, at that point, you've extended beyond the bounds of self-defense. There was no necessity to do that. There was no imminent threat. You were able to get away. The fight's being broken up at that point, and you gave vicarious 3 punches. That is assault. There's no question. The self-defense is ended. So a judge at one of these trials, they have to apply the laundry list of factors in 34.2. There's a lot of common sense that's applied to these situations too. And we know it when we see it, essentially. Fortunately, the law of self-defense, it used to be extremely complicated. There are still complications. But 34.2 was very much simplified to give this laundry list of factors. We still have case law what we apply, but I tell you, the old case law, even the most experienced criminal lawyer, every time you did a self-defense trial, you'd have to bring out your case brief, read all the cases, synthesize them, and maybe completely understand it for that one day. So I don't know how juries did, because I used to study it for hours and hours and hours just to get it ready for one trial. But thankfully, it's been simplified to a certain extent. But that's the law of self-defense in a simplified way, giving a couple common sense examples. And really, let's face it, this area of the law does ultimately boil down to common sense. Thank you for watching our video. We are absolutely committed to bringing you the best possible criminal and DUI educational videos. If you found this video helpful, please like it and subscribe to our YouTube channel. If you've been charged with a criminal offense in Ontario and require our services, please click on the link in the description below.